Away to the world across the seas, where pirates all have law degrees.
Hello, I'm Travis Anderson. Welcome to another episode of Canon Law. Today we're going to discuss some of the pitfalls that people often find themselves in throughout the day. But I thought that today I would identify some of the common issues that I find people are unaware of as they go throughout their daily life. And I wanted to highlight a few of experiences that I've had and demonstrate the principle that I wanted to teach in the process.
Wait a minute.
So, firstly, I was called several months ago about an issue related to a landlord-tenant dispute.
Isn't that weird?
Now, the landlord-tenant dispute is one that is often very difficult with people because typically people will rent some kind of facility either in a residential or commercial enterprise. Now, residential and commercial enterprises are very different in the way that they handle a landlord and a tenant. And the reason is because of the value of the lease, the length of the lease, and the purpose of the lease.
Well, duh.
When you're in a residential situation, a person is engaged in a lease for the purposes of a dwelling, a place to live. And so the domicile type understanding is going to be very different than somebody who is renting maybe a large commercial space for the purposes of transacting business.
Cool. Very cool.
Now, look upon your domain with your eyes wide open.
There's also different liabilities that exist with respect to the person who both owns and leases the property. These can get quite complicated, and so of course the contracts between those two different kinds of tenancies is what they're called. Those tenancies are going to be very different.
Savvy.
And so in the landlord-tenant situation with a residential tenancy, you're going to have a more simple understanding, a term of the lease, how many months or years you're planning on occupying that premises, and then, of course, the amount you're going to pay every month or year in rent.
I had a feeling it was too good to be true.
Now, with a commercial tenancy, it's going to be very different because those leases can last for many, many years. In fact, if you've ever remember like Kmart would not only occupy a premises that they owned, but they would also lease buildings from somebody who would build the building, maintain the parking lot, maintain the structure, maintain and maintenance the building, but then also allow them to transact their sales business inside that building.
That's right. Shop smart. Shop S-smart.
So when Kmart was able to leave the building, they didn't have to concern themselves with what happened to the building afterwards. And the landlord, the person who owned that building, could just re-rent it or release it for another purpose to another business. Now, that wasn't always the case, certainly with Kmart. Sometimes they actually did own the actual building, as many retail locations will own their actual building. But there are many situations where the retail store doesn't own it. For example, in a mall. In a mall, the local stores that you'll find in your local mall don't own the mall. The mall's owned by some kind of property company that usually invests millions or billions of dollars in building that large structure for the purposes of leasing out the spaces to different stores. That's why oftentimes you'll see different stores moving in and out.
It's a two-player swing.
Now, the difficulty arises for you as an individual as to what the complexities of the lease are as to the purpose for which you're living there. So as the owner of a residence, you are going to have a duty to maintain the property such that you can't let it fall into disrepair.
What a dump.
Now, the landlord maintains some legal obligations to maintain certain necessities. So it needs to have running water, for example, in some territories. In Texas, for example, a landlord is required to make sure that the leased premises has potable water available to it. That's just a necessity. But a lot of people find that air conditioning is something that they feel like they have to have, but air conditioning is not listed on one of those essential things. You need to be able to have bathrooms and things like that, but you don't necessarily have to have conditioned air. That's a luxury item.
All right, everyone. Chill.
But there are certain things that are found not in the lease, but in the property code. So most jurisdictions in most states will have something akin to a property code, and there'll be a chapter or section within that property code that governs these different kinds of leases, one of them for residential and one of them for commercial. Okay, Travis, thank you for rambling for all that time. Now, what's your point?
What's the point, Ventura?
Well, my point is that a few months ago, I received a phone call from a gentleman who had leased a small dwelling inside of somebody's house. And this person, for a period of time, was paying rent, but they did not have a written lease.
I don't have a contract.
So, after a period of less than a year, the person who owned the property said, "Hey, I'm getting married and I want you to move out so my new wife can move in and we don't want to share the premises with you."
Savvy.
So this friend of mine said, "Fine, sure, I'll move out." Within a few days, he had packed up and left. Now, almost a year and a half later, this gentleman that owned the house and was renting ended up in some kind of a dissolution or a divorce of his relationship. And I don't know for what purpose, because I didn't hear the whole case, but he went back and he actually sued my friend who was renting from him in order to recover rents that he felt he was owed. And I was actually shocked.
I am shocked. I am shocked. That's what I mean. I am appalled
that he was able to do this. Now, upon further investigation, I found that this person had filed this lawsuit without actually having any attorney represent him. Now, I anticipate the reason he didn't retain a lawyer is because that specific kind of suit, one where you ask somebody to move out, they do not have a lease of any specific term, and you're trying to sue for unpaid rents for some period of time after they'd moved out, that's problematic. Now, why would you even have such a cause of action? Well, if I move into a property and I rent the premises for a certain period of time, let's say a year on average, and I only live there for 6 months, and I give notice to the landlord that I'm moving out, well, I might be in what's called breach of the lease. Now, anytime you have a written document or contract and you break it, that's called breach. If you breach the lease, you could be liable, depending on, again, the jurisdiction in which you find yourself and the relevant law in the property code of that jurisdiction. You may be liable for the rent for the duration of the term. However, the landlord has another obligation, and that obligation is to mitigate. Mitigation is a principle I'm going to talk about in another couple of circumstances that we're going to address here. Mitigation is where something happens to you that's wrongful. You've been injured, you've lost your employment, you had a leased premises and your tenant moved out without notice. And now you have an empty lot. You have a car that's been damaged and you still have payments on it, or you were fired from your job and you don't have additional income, maybe even wrongfully fired from your job.
Man, that's just mean.
Well, the law dictates that a person in, again, most jurisdictions and in most case law, you're not allowed to just sit and incur the damage without acting in a way to mitigate or to lessen the amount. So if you're a landlord, you have a duty to post that the place is for rent and to take what steps are reasonable or are common for that area in order to rent the premises again. You need to make sure that you are acting in a way that is consistent with a proper landlord. in order to release the premises. So if I move out after 6 months and the year passes and I have not rented that place out in that 6 months, but I also haven't advertised the place for rent, well, I can't hold the tenant fully responsible for the whole 6 months because I have done nothing to notify anybody else to move in.
Nothing. We can't just sit here and do nothing.
But if I do take those steps as a landlord and I get the place rented, let's say in 2 months, well, then that 2 months that person had breached their lease from the time they breached their lease to the time that it was occupied by a new tenant, that 2 months is my damages. And that may be seen as reasonable. Now, again, we have the difference between the statutory law, which is the property code or the laws of the state or the jurisdiction in which you find yourself, and what we call the common law, which is set usually by court decisions. Common law is usually the decisions of the court interpreting the statutory or the legislative provisions. And that's a more complicated situation that we'll talk about maybe in another episode. But for purposes of this situation, you can't just sit idly by and allow damages to incur for an indefinite period of time or for the duration of somebody else's lease term without trying to re-rent it. So again, with an apartment, you don't want to be breaking your lease. And if you do break your lease, you need to make sure that if you're the landlord, that you don't just sit on your duff and allow the time to pass and then go sue the other person because you may not get the full value. Now, if you're the tenant in that situation, what you might want to do is ensure that, first of all, you left the premises in a decent state. Don't destroy a property and then take off and expect that you're not going to get sued for that. You probably will. Now, with respect to that, also, too, there are reasons you can break a lease in a landlord-tenant situation. And one of the reasons you can break a lease, of course, is if, for example, there's no water, there's no electricity. These things are necessities. In certain territories, they require that the lease premises have these things. The law doesn't like what we call self-help remedies, meaning, hey, landlord, my water is off. I'm not going to pay my rent. So what you would do is you would look to the property code. It'll give you a notice requirement. It will tell you how to give notice. It'll tell you the days that you have to have, and it can give you very specific information about how to do that. It'll tell you, say, you have to give the landlord certain amounts of notice, and then if he doesn't fix it, you can reduce the cost of fixing it yourself from your future rents. But again, those are going to be governed by the property code. And so also too, there is a lease at play. So you have the property code and the lease. And those two things are going to be the law that's governing what your relationship is. So make sure that before you call a lawyer, you actually read not only your lease, but you actually investigate the property code. Obviously, those things can be complicated. So I encourage you, if you don't feel like you're confident in that, please call an attorney like myself, and we can go through the documents with you and help you to understand it. Now, with respect to a vehicle collision, now when you have a property damage claim, people are often upset by the property damage. They're often upset by the personal injury claim. And so these are things that get confusing. Is somebody hits you with their car, they rear end you. And let's say the car is not paid off. You still have a note, which means you owe the bank money, and you're making payments on your car. Let's say you owe $5,000 on the car. Well, somebody hits you, and the car is totaled. And when the insurance company pays off the car, they only give you $4,000 for the car. But you owe $5,000. Well, what do you do about that? Can I just not pay the $1,000? And the answer is no, because in an insurance claim, an insurance company is only liable for the actual value of the harm at the time it was incurred, specifically with property damage. And that means if you're driving a car that you paid $20,000 for, and it turns out that the dealer was a shyster and that it was a terrible place to buy a car from and they were dishonest or whatever, and you paid $20,000 for a car that's only worth $12,000, and the next day somebody hits you and totals the car, they don't owe you $20,000. They owe you the value of the car, which could be the 12 that it was actually valued at. Now you can make arguments that they owe you the full amount, but the difficulty with that is that the harm that you've incurred is not a result of the car accident only, but also the actions of the person who sold you the car.
Swimming in it.
So if somebody sells you a car for 20 grand and that car is only worth 12, well, the law may fault you for not paying more attention and taking better care to not enter into a bad deal.
All right, spare me.
And so the insurance company isn't going to have to compensate you because you made a bad deal on your car. They only have to pay you for the actual value of the vehicle.
What did you say?
Now, people are often worried that insurance companies are going to shortchange them on their vehicle property damage. Very common argument that I find with my clients. But the reality of it is that's very uncommon in my experience, at least. Oftentimes, insurance companies will feed the person's information, specifically of the car, into this big program. And they have these big algorithms and they use a lot of data in order to establish it. And they will actually locate your exact vehicle or one exactly like it in some territory. And they will give you the full value of purchasing that vehicle. And if it's out of state, even shipping it to you. They just won't buy it and ship it to you. That's what they won't do. They'll just give you the value of that vehicle plus the costs of taxes, etc., of shipping and giving it to you.
I don't believe you.
So I find that most of the time property damages resolve themselves. It's the personal injury claim that typically is more problematic. And that's typically where a lawyer gets involved because personal injuries are much more difficult to establish what the value of a personal injury is because they're based on a whole host of different, more squishy type issues. So for example, a doctor can bill you $1,000 for a service, but that may not be what he's actually owed. And so the insurance company may say, well, yeah, I billed you $1,000, but I only owe you $200. And the lawyer steps in and says, yeah, but the doctor won't take $200. He doesn't want $200. He wants more than a $200. So you can't tell me that the doctor doesn't get paid more than $200 just because you say so.
Yeah, well, that's just like your opinion, man.
So these cases can become more difficult with respect to establishing what the value is. And then, of course, you have all the other issues more than medical. You have pain and suffering. Well, what's that number? That needs to be determined by a whole host of other factors. Loss of amenity or consortium, basically the relationships you have with other people, what are those valued at? Loss of your employment, which you would think is just lost wages, but it could be a lot more than that. So these cases become quite complicated. It's one of the reasons why I'm very apprehensive for people to go online or to use AI systems to try to establish these things, because they're not easily established, because in the court system, we present these things along with arguments to juries, and the juries make those determinations.
It's true. All of it.
We don't just want some AI computer system to just spit out an average. We want to be able to tell our story to fact finders in a jury. And that's why you'd want to hire a lawyer for these situations. And if any of this is sounding complicated to you, it's the reason there's lawyers. Lawyers have to ferret through all these different areas in order to kind of explain and help their clients navigate difficult situations. Now, I want to tell you a couple of things that I noticed in an experience that I had. Now, I've been called, surprise, surprise, to be on a jury twice. Now, I wasn't actually picked for the jury, but I was called for jury duty twice. And as I sat there listening to the jurors outside and inside of the courtroom as we were taking breaks and going back in, I noticed a number of things that the jurors did not know. So in one of those cases, it was a personal injury case or a car accident case. And I knew what was going on and I understood, but I was surprised to find out how few jurors actually understood that during the course of this case that was going to be presented, how it worked. So one of the common questions is there was a gentleman that was sitting in the defendant's seat. There was a woman that was sitting in the plaintiff's seat, and she had her lawyer, and the defendant had two lawyers. And at this time, the defendant was acting as an Uber or a Lyft driver. But he had two really well-dressed, lawyers in fancy suits.
Yes, well, I have 10 high-priced lawyers.
And then they also had like assistants with them and staff and techie people and stuff with them, with this guy. And then on the other side was an attorney, and he had assistant counsel, and they also had some people that were with them to help them with, you know, the technology and putting on their presentation, etc. And I was shocked at how the jurors were saying, "Where's the insurance company? Why isn't the insurance company here?" But of course, the defendant, as an Uber or Lyft driver, wasn't paying for 5 lawyers and their staff to show up for this case, and he hadn't been paying him the whole time. The attorneys were hired for him by his insurance company, and that's how it works. So when somebody is actually in a car accident, you actually have to sue the driver, the defendant, the person who caused the accident. Now, it may not just be the driver. It could be a company or corporation or something that is ultimately responsible for maybe the accident happened because the vehicle wasn't well maintained and it's owned by some large company. And the driver wasn't actually at fault fully, but it's because his brakes went out because they didn't maintain the brakes or whatever. So the defendant can be more than just one person, certainly. But ultimately, the drivers, the person responsible for causing the problem, are the ones that you would file suit against if you're a plaintiff who was injured in that kind of a situation. And so that's the person you pursue it. You're not going after Allstate or State Farm or something like that. That's not the defendant.
Oh, really? That sucks.
In fact, attorneys in most cases are prohibited from even talking about insurance. And there's a very good reason for that, because it can bias a jury. If a jury knows that the person sitting there, you know, the middle-aged man who feels real sorry about the thing that he did, is sitting there, and the jury believes that if they give this injured person $1 million, that this little old guy is going to have to take care of it, well, they may not give them that. And so the plaintiff's attorney wants the jury to know, no, that little old guy is not going to have to pay the judgment. His insurance company is going to pay it. And so that will bias the jury the other way. Well, now they're going to be like, well, heck, this little old guy doesn't have to pay anything. Let's give her $1 billion. And so it's often the case where jurors are not allowed to hear about certain things in a case. That's called a motion in limine, or basically things we don't talk about. And before a case starts, the opposing parties will file different motions in limine. Now, there's a whole host of other issues that we see in a daily basis. We have landlord-tenant disputes, we have vehicle accidents, and we have getting called for juries. And in these cases, there's certain things we need to know, we need to understand. And lawyers can also help us to understand those situations. And so as this channel progresses, I'll be dealing in detail many more of these certain situations that are both important to know and of interest to you. So hopefully this has been a good episode. Thanks again for joining Canon Law. Once again, I'm Travis Anderson, an attorney here in Texas. If you have a legal issue and you're in the Texas area, please reach out and give me a call or leave me a comment, ask me questions. I'll do my best to try to respond to them as I have time and as I'm able to. But again, thanks for watching, and I hope to see you next episode. Bye.
Away to the world across the seas, where pirates all have law degrees.